bailiff's voice hit the room like a gavel before I even sat down. All rise for the Honorable Judge Whitfield. I walked through the side door, smoothed my robe, and took my seat behind the bench. The courtroom settled. I looked out at the gallery, at the attorneys shuffling papers, at the couple sitting at the plaintiff's table, and I felt nothing. Not anger, not triumph, not even the satisfaction I thought I'd feel after 26 years. Just stillness. They didn't recognize me. Of course they didn't. I was 8 years old the last time they saw me, and I was crying then, standing on a sidewalk outside a bus station in Cincinnati, with a garbage bag full of clothes and a granola bar my mother had pressed into my hand like that made it okay. I looked at them for exactly 3 seconds. Then I opened the case file. I need to go back. I need you to understand what kind of people they were before I tell you what happened in that courtroom. Because if I just hand you the ending, you'll think this is some kind of fairy tale. It isn't. Fairy tales don't start with a child being left outside a Greyhound station in February. I was 8 years old and my parents had what my mother called a situation. The situation, I would learn much later, was that my father had lost his job at the plant in November. My mother had been skimming money from her sister's joint account for 2 years, and the two of them had decided, together, deliberately, over what I can only imagine were several quiet evenings after I went to bed, that children were expensive, and I was the older one, and therefore the most expensive. My brother was 4. He got to stay. My mother told me we were going on a trip. She packed my things into a black garbage bag. Not a suitcase, a garbage bag. And she drove me to the Greyhound station on Reading Road, and she said she needed to run inside and check the schedule and I should wait on the bench out front. It was 23 degrees. I waited for 2 hours before a woman named Harriet, who worked at the sandwich counter inside, came out to ask if I was okay. I told her I was waiting for my mother. Harriet brought me inside and gave me a hot chocolate and called the police. My parents never came back. The officers who responded tried for 3 days to locate them. My father had already emptied their joint checking account. My mother had called their landlord that same morning to give notice. They'd been planning this. It wasn't an accident, wasn't a breakdown, wasn't a moment of desperation that spiraled. It was organized, it was deliberate. And then they were gone. I went into foster care on a Thursday. I cycled through 4 placements in 18 months. I don't say that for sympathy. I say it so you understand the math of what that does to a child. You learn to pack fast. You learn not to put anything on the walls. You learn that kindness has an expiration date and that the safest thing is to be quiet and small and useful and to never, ever ask for anything twice. My 5th placement was with a couple in Dayton. Their names were Ruth and Clifford. Clifford died 8 months after I arrived. Heart attack. Sudden. No warning. Ruth kept me anyway. I don't know that she was legally required to, and I never asked. But she kept me and she fed me. And she made sure I went to school and she corrected my grammar. And she told me once, only once, that I was going to be someone important someday. She said it the way people say things they actually believe, not the way they say things to make a child feel better. I believed her. I was not a remarkable student. I was a determined one. There's a difference that nobody tells you about when you're young. Remarkable is a gift. Determination is a choice. And choice is the only thing that belongs entirely to you. I chose to study. I chose to apply for every scholarship I could find. I chose Ohio State. Then law school at Case Western. Then a clerkship. Then a Pluckett Defender's office. Then after 11 years of work that I am not going to compress into a single sentence because it wasn't simple and it wasn't fast. An appointment to the Hamilton County Municipal Court. I was 34 years old when I put on that robe for the first time. Ruth had died the year before. Ovarian cancer, diagnosed late, moved fast. I held her hand at the end and I told her she had been right, and she smiled in a way that meant she already knew. I thought about her every single day. I thought about her the morning the letter arrived. It came to my office address. Not my home, my office, which meant someone had done research. It was from a law firm in Columbus. The letter was 3 pages long and written in the particular dense language that attorneys use when they want to sound reasonable while saying something completely unreasonable. The summary was this. My biological parents had located me. They were filing a claim against my estate. Specifically, they were claiming entitlement to the proceeds of a life insurance policy that Ruth had taken out in my name. A policy I had only learned about myself 2 years earlier, when her estate attorney had called me. Ruth had been quietly paying into it for 22 years. The payout was $1.8 million. My parents' argument, and I want you to understand that this is real, that a licensed attorney in the state of Ohio had written this down and signed his name to it, was that as my biological parents, they had never formally terminated their parental rights, that the termination had occurred under procedurally deficient circumstances, and that they therefore retained a legal interest in any substantial inheritance I received. They also, according to a footnote on page 2, wanted to know if I'd be open to reconnecting as a family. I read the letter twice. Then I set it down on my desk and I looked out my window at the parking structure across the street for probably 5 minutes without moving. Then I called my attorney. Her name is Josephine. She has been practicing family and estate law in Cincinnati for 19 years, and she is the most precise human being I have ever met. She listened to me read the entire letter aloud without interrupting me once, and when I finished, she was quiet for a moment, and then she said, "Evangeline, this is not a serious legal claim." "I know," I said. "Their parental rights were terminated, involuntarily, by a court, in 2001. I know. There is no procedural deficiency. I've pulled the records. Everything was by the book." "I know, Josephine. So what do you want to do?" I thought about the garbage bag. I thought about 23 degrees. I thought about a granola bar pressed into my hand like a severance payment for 8 years of being someone's child. "I want them to have to stand in a courtroom and make this argument," I said. "I want them to have to say it out loud in front of a judge." Josephine paused. "You understand that means they'll know where you are, what you do." "They already know," I said. "They sent the letter to my office." Another pause. "Then okay, let's do this." Here is what I did not tell Josephine, and what I did not tell anyone, for the next 4 months while the case was being prepared. The venue assignment for civil claims in Hamilton County goes through a rotation system. I am one of 9 judges in the municipal court. The odds of the case landing on my docket were not high, but I knew the presiding judge who handled assignments, and I knew that 2 of my colleagues had conflicts that month, and I did not engineer anything improper. I want to be completely clear about that. But I also did not decline when my name came up in the rotation. I had no legal obligation to recuse myself. There was no rule requiring it. The case had nothing to do with my professional conduct, or any matter I had previously ruled on. I was assigned the case on a Tuesday. I received the notification the same way I receive all case notifications, in a standard email from the clerk's office. I read it, I saved it. I went to court that morning and presided over 4 other matters, and I did not sleep that night. Not because I was afraid, because I kept thinking about what my mother's face was going to do when the bailiff called my name. The morning of the hearing, I arrived 40 minutes early. I sat in my chambers and drank coffee and reviewed the briefs one more time, even though I had already read them so many times I could have recited them. Josephine had filed a motion to dismiss on 4 separate grounds. The opposing attorney, a man named Pruitt who specialized, according to his firm's website, in creative estate litigation, which is attorney speak for finding angles that shouldn't work but occasionally do, had filed a response that was technically coherent but legally thin. The core of their argument had shifted slightly from the original letter. They were no longer leading with the procedural deficiency claim. Josephine had dismantled that in about 6 paragraphs. Now they were arguing something murkier, that my parents had suffered emotional and financial damages as a result of losing contact with me, and that the inheritance represented a form of unjust enrichment that they, as my biological family, had a moral and legal interest in challenging. It was the kind of argument that sounds vaguely plausible until you look directly at it. I had looked directly at it, many times. At 9:15, I stood up, straightened my robe, and walked to the door. The bailiff's voice hit the room. "All rise for the Honorable Judge Whitfield." I took my seat. I looked at the courtroom. I found them at the plaintiff's table without trying. They were the ones who looked uncertain, the ones who looked like they had expected something different from the room and hadn't gotten it yet. My father was 61 now. He had the look of a man who had been handsome once and knew it. My mother was 58. She was dressed carefully in a blazer that was slightly too formal for a municipal courtroom, which told me she had thought about this, had prepared for this, had decided what impression she wanted to make. She had pearl earrings on. I had not seen her face in 26 years. I felt nothing. That surprised me a little. I had expected something, some residue of the 8-year-old who had waited on a bench in February, but there was nothing. Just the case file in front of me and the job I was there to do. "Be seated," I said. "We're here today on the matter of Hartwell versus Whitfield, case number 2024 CV 3847. Miss Wan, you may proceed with your motion." That was Josephine. She stood. What happened in the next 45 minutes was methodical and, from a legal standpoint, not particularly dramatic. Josephine walked through each of her 4 grounds for dismissal. Pruitt responded to each one. I asked questions, sharp ones, because I have never believed that a judge's job is to be decorative, and Pruitt struggled with 2 of them visibly. My parents sat at their table and watched. I could feel my mother looking at me. I did not look back. Not yet. It was during Pruitt's 3rd argument, the unjust enrichment theory, that I stopped him. "Counsel," I said, "I want to make sure I understand the factual basis for this claim. Your clients are asserting that they maintained a parental relationship with the plaintiff throughout her childhood?" Pruitt hesitated. "They assert that the involuntary termination of their rights was." "That's not what I asked," I said. "I asked whether they are asserting a maintained relationship, yes or no." "Your Honor, the circumstances of the termination." "Counsel, yes or no?" A pause. "No, Your Honor. So they had no contact with the plaintiff from approximately 1998 until the filing of this claim in 2024. "That is correct. And during those 26 years, they provided no financial support." "No, Your Honor. No emotional support. No communication of any kind. No." "And yet they are claiming an interest in an inheritance left to her by a woman who provided for her for over 2 decades. Pruitt opened his mouth. I watched him decide not to say the thing he had been about to say. "We believe the legal theory." "I've read your legal theory," I said. "I have some questions about the facts." I turned to the plaintiff's table. "Your clients are present today?" "Yes, Your Honor." "I'd like to hear from them directly on one point." I looked at my parents for the first time. Fully looked. Not the glance I permitted myself when I walked in. I looked at my mother's pearl earrings and my father's careful expression, and I said, "Can either of you describe the circumstances under which your parental rights were terminated?" My mother leaned over to Pruitt. He shook his head slightly. She leaned back. "They preferred not to answer, Your Honor," Pruitt said. "That's their right," I said. "I'll note for the record that the termination documents, which are in evidence, indicate that parental rights were involuntarily terminated following a finding of child abandonment. The plaintiff was 8 years old at the time of abandonment. She was found by law enforcement after being left outside a transportation hub in February, in below-freezing temperatures, with no identification, no money, and no adult supervision." The courtroom was very quiet. "The claim before this court," I continued, "asks me to find that the individuals responsible for that abandonment retain a legal interest in the financial legacy of the woman who stepped in to provide what they refused to. I will take the motion to dismiss under advisement and issue a written ruling within 10 business days." I gathered my papers. "There is one more thing I want to say before we adjourn." I looked at my parents again. My mother had gone very still. "I want to be transparent with the parties. I am the defendant in this case. My name is Evangeline Whitfield. I am also the judge assigned to this matter under the court's standard rotation system. I have no legal obligation to recuse myself, and I have determined that I can rule impartially on the law, but I want the plaintiffs to understand exactly who is sitting on this bench." I watched my mother's face. It moved through something I didn't have a name for. Not guilt. I don't think she was built for guilt. Something more like the specific vertigo of a person who has just understood, too late, exactly where they are standing. "Court is adjourned," I said. I stood. The bailiff called the room to its feet. I walked back through the side door and into my chambers, and I closed the door behind me and I sat down in my chair. My hands were completely steady. I hadn't expected that. I issued the written ruling 9 days later. Motion to dismiss granted on all 4 grounds. The unjust enrichment theory failed because there was no prior relationship to ground it in. The procedural deficiency claim failed because the record was clear. The remaining arguments failed for reasons I laid out in 12 pages that I wrote very carefully and that I think are some of the cleanest legal writing I produced in my time on the bench. Josephine called me when the ruling went out. "Clean," she said. "Thank you. They can appeal." "They won't," I said. "Pruitt knows this was never going to work. He'll advise them to walk away." She was quiet for a moment. "Then, how are you?" I thought about that. I looked out my window at the parking structure. "I'm okay," I said. "I'm genuinely okay." "Did it feel like you thought it would?" "No," I said. "It felt smaller and bigger at the same time." She didn't ask me to explain that, which is one of the reasons Josephine is an excellent attorney and a good friend. There are things the ruling didn't resolve, and I want to be honest about that, because I think people expect a story like this to arrive at a clean place, and life is not a clean place. I don't know what happened to my brother. I have thought about hiring someone to find him. I haven't done it yet. I don't know if I'm protecting him from something or protecting myself. I don't know what my parents did with the 26 years between abandoning me and filing that lawsuit. I know they were living in a suburb of Columbus. I know they had a house. I know from the financial disclosures in the case file that they were not wealthy, which means whatever they were looking for in that $1.8 million, it was something they felt they needed. I don't know how they found out about Ruth's policy. I have theories. I know that they were charged, following my ruling, by the county prosecutor's office, not because of anything I initiated, I want to be clear about that, but because the abandonment documents in the case record were reviewed by a prosecutor who determined that the statute of limitations had not run on certain charges. I was not involved in that decision. I recused myself from anything touching it. They pled out. My father received 2 years probation. My mother received the same. There were fines. There was a requirement to complete a family court-ordered counseling program that I know nothing about because I did not follow the proceedings. Ruth used to say that you can want justice and still let go of the outcome. She said holding on to what people owe you is like carrying a stone in each hand. Eventually, you can't carry anything else. I have been putting the stones down, one at a time, for a long time. The money is real, and I want to talk about it plainly, because people always want to know, and there's no shame in it. The $1.8 million from Ruth's life insurance policy sits in a trust. I used a portion of it to establish a small foundation. I called it the Harriet Fund, after the woman from the sandwich counter at the Greyhound station who brought an 8-year-old girl in from the cold and called for help. The foundation provides emergency support for children in transitional foster placements in Hamilton County. Clothing, school supplies, transportation, the kind of small immediate things that nobody thinks to budget for, but that matter enormously to a child who is learning what it means to be somewhere temporary. We served 43 kids last year. I still live in Cincinnati. I still serve on the municipal court. I have an apartment that I like very much. I have a cat named Persimmon who has strong opinions about when I should come to bed. I have Josephine, who is my closest friend and who sends me articles about terrible legal arguments because she knows it makes me laugh. I have the robe. I have the robe. I have the particular satisfaction of spending my days in a room where the law means something, where the rules exist and apply equally, where nobody can press a granola bar into your hand and call it enough. I am 36 years old. I am not the girl on the bench in February anymore. I am the woman who gets to decide what comes next. Ruth was right. I am someone, and I got here on my own. If your family abandoned you, if they told you by word or action or silence that you were less than worth the trouble, I want you to hear this. The ending of your story has not been written by what they did. It is being written right now, by you, and everything you choose to carry forward and everything you choose to put down. The stones are heavy. I know. Put them down when you're ready. You'll be surprised what your hands can hold. I've thought a lot about what I was supposed to feel in that courtroom. People ask me. They always ask whether it felt like closure, whether I cried, whether I wanted to say something to my parents that I didn't get to say. The honest answer is no to all of it. What I felt was something quieter and harder to name. Something like the moment you realize a wound you forgot about has already healed. Here's what I actually believe about what happened to me, and I'm not going to dress it up. The people who left me on that bench made a choice, a calculated, deliberate choice. And every consequence that followed, for them and for me, flowed directly from that choice. Not from fate, not from anything mystical, just from the simple, relentless logic of cause and effect playing out over 26 years. They chose to leave, so I learned to stay committed to school when it was hard, to stay in rooms where I felt like an outsider, to stay in the work when the work was grinding and slow and thankless. They chose to disappear. So I became someone who shows up every day, in a robe behind a bench, doing a job that requires you to look directly at hard things without flinching. Ruth chose differently. Ruth chose to keep a child she had no obligation to keep. She chose to pay into a life insurance policy for 22 years without telling me, without making it a bargaining chip, without asking for gratitude. She just did it quietly, the way she did most things. And that choice, that single sustained act of quiet decency, changed the entire trajectory of my life. That's not luck. That's not magic. That's what it looks like when a person decides what kind of human being they're going to be and then actually does it day after day without an audience. I think about that when things are hard, when the work piles up, when I'm tired, when I wonder if the small choices matter. They do. They accumulate. They compound. Ruth didn't save me in one dramatic moment. She saved me in one dramatic moment. She saved me in about 8,000 ordinary ones. A meal. A correction. A consistent presence. The sum of it was $1.8 million, and more than that, the sum of it was me. My parents came into that courtroom believing they were owed something, and I understand the logic they were using. Even if it's wrong, they created me. Therefore I belong to them. Therefore my good fortune is partly theirs. But belonging is not biology. It is not a document. It is not a claim you can file after 26 years of silence. Belonging is built, slowly, out of presence and sacrifice. And the decision to stay even when staying is inconvenient. Ruth built that. Harriet built it, in one small act, on one cold morning, when she saw a child alone and brought her inside. Josephine built it, over years of friendship that began as professional obligation. My parents built nothing. And the court agreed. I'm not telling you this to be cold. I'm telling you because I think it matters. The understanding that what you do, every ordinary day, is construction. You are either building something or you are not. And one day, the thing you built or failed to build will be the only evidence of who you were. I choose to build. I chose it at 8 years old on a cold bench, even though I didn't have the words for it then. I'm still choosing it now. That's the whole story. That's all of it.